Hey guys, welcome back to the channel, and buckle up, because today's sovereign citizen isn't just taking loses, he's collecting them like it's a full-time job. For this guy, losing in court isn't bad luck, it's a lifestyle choice. We're diving into 3 separate cases across 6 full hearings, and every single appearance is a brand new episode of How to Ruin Your Own Day in Court. He talks himself into trouble, argues with reality, and somehow makes each hearing worse than the last. Seriously, this is a masterclass in self-inflicted legal chaos, and just when you think it can't possibly get more painful to watch, it absolutely does. Let's get into it.
We are on the record with file number 22-186783, J.P. Morgan Chase Bank versus Marcus Campbell, date and time for pretrial appearances.
Good morning again, Your Honor. Jim McCardle on behalf of J.P. Morgan Chase, P numbers 82443.
And your name, sir?
My name for the record is, I'm the authorized representative here on special appearance, the director and the beneficiary of the legal name of Marcus Campbell.
Are you Marcus Campbell or not?
I am.
All right. Where are we on this file, gentlemen?
Well, Your Honor, I filed a motion for summary disposition. I've received a notice from the court saying that this was a final settlement conference, but I was hoping that the court was going to take up my motion for summary disposition. I've not received an answer or any kind of a responsive pleading to my motion for summary disposition. There have been numerous filings by the defendant, virtually none of which I understand.
It's all right, Mr. McCardle. The problem isn't you. When a document is pure nonsense, the giveaway is the nonsense leaking out of every single line. No one expects you to interpret something the defendant himself clearly doesn't understand. And let's be honest, the guy who sold him that fantasy paperwork didn't understand it either. This isn't law, it's confusion passed down like a family heirloom. Generation after generation of recycled legal gibberish. Confidently wrong and completely useless.
So that's, as far as I'm aware, what the status of the case is.
Mr. Campbell, did you receive his motion for summary disposition?
I have sent a brief. I sent a brief to the courts.
Sir, are you listening to me?
Did you hear what I just said?
No.
I just answered. I sent the brief.
I asked you if you received his motion for summary disposition.
Yes, I have.
Okay, so then I'll just calendar it, that's all. Is there anything else outstanding?
Not that I'm aware, Your Honor.
Anything else outstanding, Mr. Campbell?
Yes, I do have something. I did respond to the courts and to the complainants.
Okay.
But before this matter go any further, I would expect 21 days and a provided proof of claim of evidence of the legal and lawful authority of the public to bring this to me.
So you're asking for discovery? Adorable. Unfortunately, that only works if you file an actual motion, done the right way, served the right way, and written in something the court recognizes as legal English. And I hate to be the bearer of bad news, but sovereign citizen arts and crafts don't qualify. You're going to have to put down the coloring book, resist the urge to eat all the crayons, and maybe save just one to write something that vaguely resembles a real motion. Because until that happens, this request isn't just going nowhere, it's not even leaving the launch pad.
Okay. Sir, you can file whatever motion you want. Right now, I'm going to calendar Mr. McCardle's motion for summary disposition. That if you say you filed an answer to it, we'll be prepared to go forward then. The motion for summary disposition, gentlemen, will be heard April 10 at 11 o'clock. We are going to call file number 22-186783, J.P. Morgan Chase versus Marcus Campbell, date and time for a motion for summary disposition. Could I have your appearances?
Of course, Your Honor. Jim McCardle appearing on behalf of J.P. Morgan Chase.
Bar number?
82443.
And your name, sir?
Marcus Campbell in special appearance.
Mr. McCardle, this is your motion.
Yes, Your Honor. Your Honor, we had issued demand to the defendant on March 15th of 2022. Receiving no answer, we then filed suit against the defendant on May 13th of 2022. Proof of service was finally obtained on September 26th of 2022. The answer was filed on November 14th of 22, and then we subsequently filed our motion for summary disposition on 12/15/2022.
This circus has been running since May of 2022. And if sovereign citizens deserve a gold medal in anything, it's their Olympic-level talent for turning the simplest, most straightforward case into a never-ending endurance event. They stall, they delay, they dodge, they file nonsense. They drag everything out like time itself is part of their legal strategy. But here's the punchline, and it never changes. No matter how long they stretch the timeline, no matter how many pseudo-legal tricks they throw at the wall, the ending is always the same. They lose every single time.
A series of responses, as it were filed, the last of which is a response to plaintiff's counter-defendant's motion to strike, in which the defendant has a number of things, but the chief among them, in paragraphs 5 and 6, the defendant agrees with our motion, the allegations in our motion, that he's in default, and that there is currently due and owing a balance of $18,610.79. And then he in paragraph 8 in our motion says defendant's answer fails to refute the obligation of the plaintiff. The response is defendant counter plaintiff agrees. However, defendant counter plaintiff's pleadings are not redundant, immaterial, impertinent, scandalous, or indecent in manner. So I'm not sure what that's supposed to mean. The upshot of this is, Judge. Oh, there's one other thing. Yeah, he suggests in his paragraph 1E that my client is practicing law without a license. Well, we're here on behalf of our clients, so my client corporation is not acting without an attorney, so that's irrelevant. So basically, what I'm asking for is judgment in the amount of $18,610.79. In essence, because the defendant has agreed that he owes the money.
I'm definitely noticing a pattern here. The last sovereign citizen pulled the exact same stunt, spent the entire hearing screaming about a debt that never existed, and then promptly went on to confirm every single detail of that debt on the official record. And that's what happens when your entire legal strategy is ripped straight from Pro C for Dummies. You don't just weaken your own argument, you start building the other side's case brick by brick, in real time, without even realizing you're doing it.
Mr. Campbell, your response.
I disagree, and I'll stand on my brief.
And you stand on your pleadings. Okay.
Which was
All right, the court's prepared to move forward in this matter. This is a motion for summary disposition filed on behalf of plaintiff and notice for hearing today. Plaintiff's motion for summary disposition was filed on December 15th, 2022. Following that date, the court register of action does not appear that any pleadings were filed by the defendant. Michigan Court Rule 2.116G4 is relevant here. A motion under sub-rule C10 must specifically identify the issues as to which a moving party believes there is no genuine issue as to any material fact. When a motion under sub-rule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his pleadings, but must, by affidavits or otherwise provided in this rule, set forth specific facts showing that there is a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. No response was filed to the plaintiff's motion for summary disposition. However, in his earlier pleading, which is really not relevant because they were not, again, filed in response here, the defendant admitted that he owed the money. So that's going to be it. Court finds there is no genuine issue of material fact. Plaintiff is entitled to summary disposition as prayed for under MCR 2.116C10. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be perfected in 21 days today in the Wayne County Circuit Court.
Well, you definitely nailed the special part. I'll give you that much. Not in the way you were hoping. But hey, a win's a win, even when it's completely unintentional. And somehow, that's kind of the whole theme here.
We are on the record. We're calling file number 22198-398. The file is entitled Portfolio Recovery Associates versus Marcus Campbell. Your appearances.
Yes, good morning, Your Honor. Michael Kirshenheiter for the plaintiff, P75722.
And what is your name, sir?
Marcus Jamel Campbell in special appearance for.
In special appearance for what, sir? You filed an answer here. All right.
Marcus Jamel Campbell special appearance.
Well, at least you got the fucking special part right.
First thing I want to know is Mr. Kirshenheiter has filed a motion for summary disposition. Did you receive that motion, Mr. Campbell?
I'm not sure if I have, but I'm wondering if you all have my paperwork. I'm not sure if I did.
I have a motion filed by Mr. Campbell. My question is, did Mr. Kirshenheiter, did you receive his motion?
I perceive so.
Okay, so you got the motion for summary disposition filed by the plaintiff. Mr. Kirshenheiter, did you get the motion filed by the defendant?
Your Honor, I'm not exactly sure what we received. It just says brief and memorandum of law.
Yep. Okay, that's fine. We have that. Now, Mr. Campbell, my question
Yes,
to you is that your answer to the motion for summary disposition?
Yes, it is.
That is your answer.
Right.
I'm willing to bet his so-called brief memorandum of law was submitted on a piece of paper that still had dried spit on it. And sure, technically, a memorandum can be used to respond to a motion for summary disposition, but only if it actually lays out the jurisdiction's legal requirements, explains why summary disposition doesn't apply, and, this part's important, cites real statutes and real case law, not whatever he dug up on Reddit at 3 o'clock in the morning. If he managed to do all of that correctly, someone should probably check my vital signs, because I'm not going to believe it.
Okay, so then neither side wants any discovery, and all I need to do is calendar your motion. Is that what you're both telling me?
Yes, as long as it.
Okay, here's what we'll do. The court will calendar for May 1st at 11 o'clock, plaintiff's motion for summary disposition. We will receive Mr. Campbell's pleadings denominated brief and memorandum of law and proof of service as the answer to that motion. This is 22198-398, Portfolio Recovery Associates versus Marcus Campbell. Date and time for a motion for summary disposition. Could I have your appearance?
Good morning, Your Honor. Jeff Werber, P67124 on behalf of the plaintiff.
And what is your name, sir?
Marcus Campbell in special appearance.
Mr. Werber.
Yes, Your Honor. Today's the date and time set for plaintiff's motion for summary disposition pursuant to MCR 2.116C9 and C10. This was a Care credit card issued by Synchrony Bank. It was opened up on November 29, 2018. As the invoices attached to the motion reflect, the last payment made on this account was June 30th, 2021. At the time of charge-off, it left a balance of $3,171.94, the exact amount the plaintiff filed the lawsuit for. Those monthly invoices were all mailed to the defendant at his current address, which he placed on his answer and his response to the motion for summary disposition. Defendant made payments on this account for almost 3 years and has not shown that he ever objected to those monthly invoices that he received in the mail. He filed a general denial answer and a lengthy response to plaintiff's motion, but neither provide this court with the genuine issue of material fact or a true defense to this motion. So plaintiff requests that the court grants its motion for summary disposition today.
Mr. Campbell.
Yes.
Your response, sir.
I sent a brief regarding the denial.
Yes, the court had the opportunity to read your brief, and I thought it was an interesting set of matters that you set forth here.
Forthwith is the judge's polite professional way of saying, "Sir, you have absolutely no idea what you're talking about. It's basically the courtroom equivalent of calling someone a complete idiot, just wrapped in legal vocabulary and delivered with a straight face. And honestly, I'll take it. Because if that word means this nonsense ends immediately, then at least I won't be forced to sit through another minute of it or choke down any spotted dick today.
But I'm prepared to rule on this matter. Is there anything else you want to say in addition to what was filed?
Right. I have not contracted with them, and I do not wish to contract with them now. I just want to make sure that the brief is on the record, though.
I see your brief and memorandum of law and proof of service.
Yeah. So all of that is on the record.
I see it's filed here, and I see
Yes, sir. That's all I know.
I know, for example, that you cite federal rules of civil procedure. I
Right.
know, for example, that you cite 28 USC 2403. I
Mhm.
further know you cite MCR 2.614. Okay, I'm prepared to rule.
Yeah.
Having had an opportunity to read the pleadings both by Mr. Werber and by Mr. Campbell, the court is satisfied that there is no genuine issue of material fact. The motion for summary disposition under MCR 2.116 C10 will be granted. I'll send you gentlemen out of order. Did you attach an order, Mr. Werber?
Yes, Your Honor, there is an order attached to plaintiff's motion. It's right before all the exhibits.
I see it. I see it. All right, the
Right.
court will enter that today. Mr. Campbell, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court.
He's 0 for 2 so far. And at this point, I'm honestly rooting for that legendary third time's the charm. Not for him, obviously, but for the rest of us enjoying a front row seat to this legal derailment. Every filing, every argument, every appearance is just another carriage falling off the train. And with that, anyway, moving on.
All right, this is case number 22196913. This is Capital One versus Marcus Campbell. The matter is before the court set for a status and scheduling conference. I'm looking for Marcus Campbell. If you're on the Zoom, please say something at this time.
Yeah, Marcus Campbell and special appearance.
All right, thank you, Mr. Campbell. All right, today is the date and time set for a scheduling conference regarding this matter. It appears that this is a complaint wherein the plaintiff claims that there is a total amount of $1,874.21 that's owed as a result of a Capital One bank account in this matter. All right, and I received an answer that was filed in this regard, and it appears that the answer is a general denial of any claim of obligation regarding the indebtedness. Counsel, has there been any opportunity for the parties to talk about whether or not this matter could be resolved?
Your Honor, I've not spoken with Mr. Campbell today. Based on some documents that he filed and sent to our office, I don't believe it will be helpful to speak as far as getting it resolved. My office will be filing a motion for summary disposition.
Right now, anything you wish to say at this time, Mr. Campbell, regarding whether or not there is a prospect of resolution in this matter, sir?
No, sir. I just want to be sure that my proof of service, my brief, and my fee schedule is on the record. That's all I need.
So let me get this straight. You're actually demanding they pay your fee schedule for your efforts to recover money you took and never paid back? That's not confidence. That's delusion on a level I didn't even know was available to the public. Honestly, you should just be grateful society doesn't charge a fee schedule for wasting everyone's time and occupying oxygen the rest of us could have used. Because if it did, you'd be in debt for the remainder of your natural lifespan.
All right, what I've received, and I've received your answer to the complaint in this matter, as I've indicated previously. That was filed with the court on March the 10th, and that answer sets forth a 23 count response, and then it sets forth affirmative defenses items 1 through 9. That's what the court has received. All right, I am going to set this up on a schedule, allowing the parties to engage in the practice of discovery, that is to request any information that you may need from the opposing party in writing, and that information will be turned over. This process also allows for the submission of interrogatory sets of questions. It allows for requests to admit and other items of discovery that may be allowed under the court rules. Accordingly, I'm going to put this on a 60-day schedule with the return date in this matter set for the 13th of June, 6/13, 23.
So on June 13th, he's handed one last golden opportunity, a final chance to prove there's at least a faint ripple of brain activity happening upstairs, one moment to show he isn't a fully certified grade A disaster. And what does he do? He detonates the entire thing by not even bothering to show up. And honestly, that tells you everything you need to know. That's his entire life story in one sentence. Give him a chance to succeed, and he'll still find a way to fail at the easiest part of all, basic attendance.
The defendant in this matter, Marcus Campbell, or anyone representing Mr. Campbell, if you're on the Zoom, please say something at this time. The matter is set on for 9:30 a.m. It is now approximately 9:39. Let me ask you, counsel, have you had any contact with Mr. Campbell? Any response to the motion for summary disposition, updating on any information that you may have at this time?
No, Your Honor, no response to the motion and no contact from defendant.
Defendants failed to appear. Moreover, in reading the motion and the issues raised thereby, as well as the predicate history of this these particular transactions herein, I don't see that there is a genuine issue of material fact in this matter, and that defendant, I have to conclude that the plaintiff is entitled to judgment as a matter of law. Moreover, I do not see where a defendant has raised a valid defense to the claim. And so the motion for summary disposition will be granted at this time.
All right, Mr. Johnson, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, you can put your hand down. Mr. Johnson, you're before the court for a plea, State of Georgia versus Keith Nathaniel Johnson. You're represented by attorney Justin White, who's here with you in the courtroom. Mr. White, what is your client plea to the offenses before the court? 1, obstruction of an officer; 2, obstruction of an officer; and 4, criminal trespass.
Your Honor, he's pleading to count, I guess this is 4 criminal trespass. The 2 obstructions are to be null pros, Your Honor. He's pleading guilty.
All right. So, Mr. Johnson, by entering a plea of guilt to criminal trespass, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest shall negatively impact your immigration status. Do you understand all of these things, sir?
Yes.
All right. Factual basis recommendation, please.
A man stands before the judge, swears an oath, and pleads guilty to criminal trespass. The legal rights he's giving up are laid out one by one, making it clear this is no small matter. At first glance, this feels routine, but beneath the formal words, something bigger is clearly brewing.
Yes, Your Honor. On May the 7th, 2023, officers were dispatched to Jonesboro, Georgia, in Clayton County. Your Honor, the officers were dispatched because of a domestic disturbance. Your Honor, the officer indicated that the victims, who in this case were defendant's parent, call indicating that defendant was cursing them out. Your Honor, the officer indicated that the victims stated that whilst they were waiting for the officers to be present at the incident location, the defendant then locked the door, stood in front of the door, and locked his parents out of the house. Your Honor, when the officers arrived, the officers made contact with the defendant. The officers then requested defendant for ID. Defendant refused. The officers asked for defendant's name and date of birth. Defendant refused. Defendant then started acting aggressively towards the officers.
Now the details come out and the tone shifts fast. Police were called to a domestic disturbance involving the defendant and his own parents. He allegedly cursed them out, locked them outside their own home, refused to identify himself, and resisted arrest. This isn't just a technical violation, it's a family conflict that spiraled into criminal behavior, and the courtroom can feel that tension immediately.
The officers then proceeded to arrest defendant. Defendant stiffened his body to pull away from the officers, trying to avoid being handcuffed. Your Honor, that is the factual basis. The state recommendation will be counts 1 will be non-pros, counts 2 will be non-pros, counts 3 will be 12 months to serve 25 days. The balance will be suspended and do not return and stay away.
All right, so Mr. Kotoroka Yeda, make sure that the record is complete, that you have the address that they're to stay away from and the name of the victims who they're supposed to stay away from. So this is Mr. Johnson. Mr. White, on behalf of Mr. Johnson, do you have any concerns about his ability to enter into this plea?
No, Your Honor.
All right. And Mr. Kotoroka Yedem, did you want to provide that information?
Yes, Your Honor. The first victim will be Mr. James Keith Johnson, and the second victim will be Miss Alana Johnson.
White, anything else on behalf of Mr. Johnson?
Your Honor, I just want to put on the record Mr. Johnson has been in jail since May of this year. He's been in jail for a while. We did file the motions he originally pled not guilty back in June. Then we filed a motion. The motion was continued, I believe, 2 times.
At this point, it looks like the case is wrapping up. Charges are dismissed, sentencing is announced, and the judge even apologizes for the defendant's long stay in jail. He's told he'll be released the same day. It feels like a clean ending, almost anticlimactic. But just as the moment settles, something unexpected happens that completely changes the direction of the hearing.
And it's kept being put on different calendars, hence why he's been in jail for such a long time. Based on some information he told me the last time I spoke with him, we've just gone ahead and decided to enter a plea, Your Honor.
Okay. All right. So, Mr. Johnson, my apologies for the extended stay. The court is going to accept your plea. I'll sentence you to 12 months to serve 25 days credit for time served. Balance will be suspended as long as you do not go back to the incident location and that you do not have contact with the individuals listed for the remainder of the 12-month period. Okay. All right. You can go back with the sheriff's office and you should be released today if there's nothing else holding you. All right, who's the gentleman coming forward?
Oh, Your Honor, the victims in Mr. Johnson's case are here. I believe they wish to speak.
All right, let's hold Mr. Johnson up. Come on up, sir. Come on up.
I'm James Keith Johnson, father of Keith Johnson. I do not feel threatened by him, and it's okay for him to return.
All right, so Mr. Johnson, let's have a brief conversation. So how old is your son?
Could you
How old is your son?
27.
Okay, and does he have any issues that the court should be aware of?
No, ma'am.
Okay, so no concerns for mental health or anything like that?
No, ma'am.
Okay, all right, so is he living separate from you?
He's living with us. He's a resident there at 655 Washington Drive.
Okay, what is the reason that he's living with you as a grown man?
He was helping him out.
So, Mr. Johnson, I'm a parent, so I speak as a judge and a parent, and I've been doing this for 11 years. It is hard for adults to be adults in the same house. If somebody doesn't have skin in the game, then if they want to be an adult, but they ain't put nothing on it. It's very difficult, and that causes a lot of problems. And a lot of what I see when there's conflict between a parent and an adult child is a parent thinking that they're helping an adult child when really you're
The victims step forward, and they're the defendant's parents. The father says he doesn't feel threatened and wants his son back home. That's when the judge pivots from legal procedure to real-life truth. She starts asking hard questions about age, responsibility, and boundaries. What follows isn't a lecture out of anger, but concern, because this isn't just about a crime, it's about a pattern.
You're breaking their wings, because until somebody gets out in the world and learns what they need to do to go forward in the world and be successful, then any attempt to help them really is a hindrance. Every successful person that I know personally, whether their parents communicated it to them like verbally, or whether they made it clear at the age where they finished high school, you can do any of these things, military, college, trade school, work, any of those things, but you can't continue to live here. And it is only when we release our grown children into the world that they learn how to appreciate everything that you worked hard to provide for them, because they got to work hard to provide for themselves. And so at 27 years old, y'all need to give him an eviction date. This is the date by which you will be getting out of our house and establishing yourself separately. Because continuing to hold on to him and we helping him, you're not helping him. You're not. And all it's going to do is cause conflict, because you can't be grown in another grown person's house. I'm not grown in my mama's house. I am well of age. I'm sure I'm probably both older than both of y'all. And I walk into my mama's house, and in her mind, I'm still 12. I can't be grown in her house. And I understand that. And so I govern myself accordingly, and then I get my tail back onto my house where I am grown. But I also know that being out in the world has made me resilient, responsible, and it has made me understand that I can achieve and do things on my own 2 feet. And so when parents think that they're helping, we're paying the bills, he's here, he might be working a little job, but we doing everything else. You're not making him a man. What age did you get out in the world and start having to work and support yourself, Mr. Johnson?
20.
Excuse me?
20, ma'am, 20.
Okay, so why are you holding your son back from experiencing what you experienced?
We're working on setting him free.
No, because you're actually handicapping him, and I'm just gonna tell you. Everybody I hear, they'll say, well, I was out there at 16, I was out there at 18, I was out there at 20, but then their 30, 27, 30, 40-year-old son is still laying up in their household. And my grandmother had a phrase she used. She had 13 children, and she said, what you're not gonna do is be laying up here using up all my electricity, because all that does is make him, here's another term, sorry. You're taking away his ability to stand on his own 2 feet and be a man. Want and need they will build character quicker than anything else. If you want something and you got to figure out how to get it yourself, or if you need something and you got to figure out how to take care of yourself, those things build character. Helping somebody turns them into somebody who can't do nothing unless somebody is helping them. And I give you this long conversation because so many parents, hopefully there are other parents out there watching, so many parents are helping their kids into irresponsibility. Because if you pass from this earth, Lord forbid that happens anytime soon, what is going to happen to that person who can't stand on their own 2 feet? I'm just saying, you can love somebody too much. Make him responsible. At 27 years old, there is no way he needs to be still up in y'all's house, even if he had to get 10 roommates and work 2 jobs. Because I worked 2 jobs in college. I worked 2 jobs in high school. I mean, if you have the drive, my husband ain't never had less than 3 jobs. So if you have the ability to work and take care of yourself, that's how you build That's how you build for yourself. Does he have children?
No, ma'am.
Good. Because that's one less person that he has to be responsible for. But at 27 years old, he got to get out and be responsible for himself. Because all of this, we gonna keep bringing him back in here, and he's gonna keep causing trouble. I wish I would raise my hand to my mama. I wish I would bar her from her own house. I wish, and my grandmother, she'd have pulled a switch off the nearest tree. So the old school ways, they worked. They worked for a reason. Okay. All right, ma'am, did you wish to say anything? I didn't want to, keep you from expressing yourself. But I'm just saying, y'all hurting him by this whole keeping him in the house thing. Work out a plan, work out a timeline for him to get out and get on his own.
Yes.
This final stretch turns into a raw, unforgettable monologue. The judge explains how overhelping adult children can destroy independence, character, and growth. She warns the parents they're not raising a man, they're delaying one. It's tough, personal, and painfully honest, ending with a lesson far bigger than this case. If this hit home, like the video, subscribe to the channel, and we'll see you in the next one.
All right. Y'all have other children?
Yes.
And now y'all's other children living at home too?
Yes.
Oh my Lord. How old are they?
Well, my daughter needs help. She has some mental problems.
Okay. Well, that's who you should be focused on. Are you a member of the National Alliance of Mental Illness, NAMI?
I've been to their meetings before.
Okay, good. That's a good organization that may help you help your daughter. But yeah, that's who y'all should be focused on, really focused on. And then if your son is not able to stand up on his own 2 feet, how is he ever going to assist his sister if something should happen to y'all and y'all aren't able to help her? He got to be established in order to come back and help her. But if he ain't got nothing and can't do nothing, how's he going to help her? All right, just consider these things. All right, and if you want no violent or harassing contact, I'll give it to you. I don't have a problem with that. Miss Wright, you can alter the sentence to no violent or harassing contact for Mr. Johnson. But I want y'all to be mindful that instead of raising a man, you're continuing to coddle a baby. All right? All right, y'all are free to go at this